Hello, my name is Ifoma. Welcome to Legal Junction. Today we are going to be talking about the mistakes that landlords make when issuing quit notices to their tenants. Quit notice is a document that terminates tenancy. The law requires that before a landlord can get an order of possession in respect of a particular premises, they have to first of all terminate the tenancy of the tenant, thereby issuing such tenants a notice to quit. Quit notice is a very technical document, and as such, any mistake on it renders it defective. A defective notice cannot terminate a tenancy, and a court cannot also act on a defective notice to issue an order of possession. So it is important for us to know these mistakes in order to be able to avoid it as landlords and to be able to spot it as tenants. These mistakes are numerous, and because of that, I grouped them under three headings. 1. Mistakes relating to time and date. 2. Mistakes relating to improper descriptions. And 3. Relating to improper endorsement and signature by the landlord or his agents. Today we are going to be treating the mistakes relating to time and date. Number 1 mistake: incomplete or insufficient notice to quit. The law requires that for a yearly tenant, he is entitled to 6 months notice. A half-yearly tenant is entitled to 3 months notice. A monthly tenant is entitled to a month's notice, and a weekly tenant is entitled to a week's notice. But sometimes when the landlord starts having issues with the tenant, or the tenant stops paying his rent as at when due, the landlord will be in a haste to send the tenant out of the premises, and because of that, issue him an insufficient notice. Maybe issued a tenant that is entitled to 6 months notice might now be issued 3 months notice. That is an insufficient notice. Also, an incomplete notice is when a landlord issues 6 months notice to a tenant that is entitled to 6 months notice, but the notice is dated on the first day of the month in which the quit notice is supposed to start calculating. For instance, a quit notice that is supposed to start counting or calculating from the 1st of May should be issued and dated in the month of April. Otherwise, it becomes an incomplete notice, because the court provides that a month should be 1 clear month, 6 months should be 6 clear months, a week should be 1 clear week. So anything that deviates from that is incomplete or insufficient, and an incomplete and insufficient notice is a defective notice. It cannot terminate a tenancy, and the court cannot grant an order of possession based on it. Number 2, there are situations when landlord issues quit notice that terminates on a non-existent date or on an impossible date. For instance, I've seen a notice that was issued on the 24th of September 2019. It was a 3 months notice, and it was meant to terminate on the 31st of January, the same 2019. That is a mistake on the part of the lawyer, but it is an impossible date, and such quit notice is very defective and does not terminate any tenancy. Also, the 29th of February in a year that is not a leap year is a non-existent date. The 31st of June is a non-existent date. So any quit notice that terminates on this kind of date is defective and does not terminate the tenancy. Number 3, landlords can issue quit notice that ends or terminates on a particular date and then add or before to the date. That is very wrong. A quit notice is supposed to be specific and unambiguous. The date for termination of quit notice is normally seen in the last paragraph of the quit notice, and it usually reads thus: which you hold of him as a yearly tenant thereof on the 31st day of May 2020. But some landlords will write it like this: which you hold of him as a yearly tenant thereof on or before the 31st day of May 2020. It has become ambiguous because the tenant now does not know when the quit notice will terminate, whether it will terminate on the 31st day of May 2020 or before the 31st day of May 2020, such quit notice is defective and does not terminate anything, as the date is not specific. Number 4, some landlords might issue a second quit notice when the first quit notice is valid. This normally occurs when a landlord issues a quit notice to a tenant that is in arrears of rent, and the tenant comes and meets the landlord and pays his arrears and pleads for some time to pay the rent, the advance rent that is already due. If the landlord now waits for 1 month, 2 months, 3 months, and the tenant is not coming up with the rent that is due, he might go ahead, instead of issuing the tenant a 7 days notice, he will now issue the tenant a new quit notice. That new quit notice is defective and it does not terminate anything, as the tenancy has already been terminated by the first quit notice. Number 5, a quit notice that is issued to terminate before the anniversary of a tenancy. The law provides that quit notices issued to any tenant that his rent is still subsisting must terminate on the anniversary of the tenancy. Some state laws, like Lagos state law, provide that it can terminate on or after the anniversary of the tenancy, but there is no law that provides that quit notice should terminate before the anniversary of the tenancy. Anniversary of the tenancy is the date when the rent of the tenant expires, the midnight of that day. But you don't need to put time in the quit notice, just put that date. If the rent of the tenant is expiring on the 31st of May, just put on the 31st day of May 2020. But any quit notice that terminates before the anniversary of the tenancy is a defective quit notice and does not terminate the tenancy, and the court cannot grant an order of possession based on that. Thank you very much. I hope this video is very insightful. Please subscribe to our channels, as we are going to be bringing you more insightful and interesting topics, and we would like you to be the first to get notification once we release any video. See you in my next video. Stay safe and stay out of trouble. Bye.